Good afternoon, folks. This is John Berger coming to you from high atop ACERO World Headquarters in a finally sunny day in Atlanta, Georgia. Thanks you all for joining us. Greetings to everybody far and wide, and a special hello to our neighbors to the north who are digging out of an early season snowstorm. I hope things are getting better for you up there. We had a lot of rain here, but other than that, nothing too serious. I am really pleased to again be joined today by Marianne Burright and Stephen Wilson from the University of Georgia, here to talk to us about publication agreements. This is the third in a three-part series that they've crafted for us. We've had really good response to the first two and are delighted to have them back again today. As always, I need to do a little bit of housekeeping before I turn it over to our speakers. I think everybody has heard this before, so I will keep it quick. Basically, you can hear us, but we can't hear you. If you need to communicate with us, you can do so in one of two ways, either through the questions box on your little e-meeting panel or raising your hand on your little e-meeting panel. Either one will work. Just a quick note about future webinars. Tomorrow, for those of you who are involved with shared print activities, is our Scholars Trust Town Hall meeting. And then we have two more webinars for this semester, one this Friday, part of Show and Tell, Digital Scholarship Show and Tell, with the folks from the University of Georgia again, and Georgia State University. And then next week, for folks from Florida, South Florida and Florida International. And apologies for the misnumbering. The Florida thing was supposed to happen in October, and there was a scheduling snafu, and it just, so in any case, they got out of order. But if anybody is interested in doing digital scholarship show and tell stuff for next year, we are looking for folks. We have one sort of tentatively scheduled for mid to late spring, but other than that, we don't have anybody signed up. So by all means, drop me a line. And also, if you have other ideas, the reason we're having this series with Marianne and Stephen is that they dreamed it up and contacted me and said, like, we want to do this. So so here we are. And I would love to have other ideas like that. By all means, drop me a line. Also, this session, as always, is being recorded and made available under a Creative Commons license posted on our website, as you see there, acerl.org/archive. And lastly, the ACERL Code of Conduct. Please play well with others. If for some reason you feel like you are being mistreated, by all means, contact me or an ACERL board member when you feel safe to do so. Your report will be treated confidentially, and we will take appropriate action for anybody we find to be misbehaving. That's it from me. Happy to turn it over again to Marianne and Stephen, who should now be seeing the pop-up box to share their screen.
Welcome, y'all. Thank you so much for joining us and braving the elements to come and join us for the last in a series of adventures and contracts. And also, since this is our last session, I hope you can still keep in touch with us by email if you have any questions. Now, of course, we can't comment on your specific questions or specific situation, but we can certainly help point you to the right information and tools that may help you. Sorry, just a moment while we get our slides in order. Okay, so last time we talked about licensing agreements, and they were mainly aimed at acquisitions librarians, hoping to be able to get some clarity on the provisions that are in a typical license agreement and how to become better advocates for their institutions through the contract. So today we're talking about publication agreements. There's quite a bit of an overlap and similarity between the provisions that were in the licensing agreement session and also with publication agreements. But just a few things to make a note of. There is some difference here with publication agreements because they involve the author's copyrights and also a contract. So just some introductory questions to kind of give you a sense of what we're going to be doing today. And also, hopefully, that this is going to give you some tools to fold into your scholarly communication program and, you know, to help you feel a bit more empowered to work with faculty as they navigate their publication agreements and be able to work with their funding agencies. And if you have an open access institutional policy, that they would also be, you know, directed in a way that is more accurate. So just an introductory note about publication agreements. Publishing agreements are, of course, negotiable. Second, the provisions can be somewhat confusing, but they have similar features, and today we're going to step through an example of a real publication agreement and kind of break down and unpack some of the language with you. The third thing is that authors often have certain mandates that they need to follow through their funding agency or institutional repository and policies, and we're going to be talking about that as well within the example that we've chosen. Also, keep in mind that when you're working with faculty or students in helping them to understand a publication agreement, that there's always going to be a specific context in which that they're dealing with. For example, ETD submissions and open access policies. There's a faculty member who's going to be publishing a peer-reviewed article or, of course, a book publication. So I just want to step through a bit of a review of contracts before we launch into our topic for today. And this is for the benefit of those who haven't joined us before, or again, if you're a third-time participant, you know, this is good review. So a contract is legally binding obligation to do something in exchange for something else, either a promise or a return performance. An enforceable contract has to have an offer, acceptance, and consideration, which are the legally required elements for an enforceable contract. An offer has to be definite, specific, and leave nothing for negotiation. The acceptance has to be made in the form in which the offer has been made. So in other words, you can't give a counter offer and say, you know, this is part of the package. No, a counter offer is starts the clock over again on negotiation. And of course, consideration, which we spent quite a bit of time on. Consideration is the core of what an enforceable contract has to have, and it's basically an exchange, right? I mean, it's exchange of money or goods or services between two or more parties. So that precludes a gift, for example, from being a contract. And also that there has to be, if there's a written document memorializing the contract terms, the courts will look to that first and maybe the only thing to determine what the agreement contemplates. So a review of our second session, which was licensing agreements, and this is kind of good to, you know, warm up a little bit for the publication agreement portion of our today's session. A typical licensing agreement includes categories of different provisions. The first thing is introductory, which basically outlines who's involved in the contract, the party names, why they're contracting, and so it touches on all the basics. The definitions and defined terms are standardized terms that basically will appear in a contract throughout the contract more than once and need to have specified definitions to avoid ambiguity or vagueness and avoid any legal issues arising out of ambiguity. The action sections are basically where all the good stuff happens. This is who's doing what, how, when, under what conditions, and so forth. And the action sections involve the promises of what one party does for another, and how those will be carried out. And then finally, we have the endgame and general provisions, which are also called boilerplate, but I don't like that term because there's typically really nothing boilerplate about those. They can vary, from different contexts. They also include how the agreement will end. So when you're dealing with a license, you'll want to pay special attention to the conditions under which the agreement will end. If it's a renewable license, how and when does it renew? Okay, so again, I just want to talk through action sections a bit more because we also will be visiting them in today's session. And the important things to remember are representations and warranties. A representation is a statement of past or present truth on which the party that wants to get into the contract is relying. And the warranty is the guarantee of the truth of that statement. Covenants are promises that carry legal obligations for the party that's making them. And they're explained by the language of shall. So I shall sell my car to Stephen, that sort of thing. Conditions are always, you ask yourself, conditions to what? Are they conditions to the covenants, the promises that are being made, or conditions to discretionary authority or what have you? And discretionary authority is a concept that allows a party to be able to do something. It gives a party a choice or permission. And if you may remember from our last session, it's always good for the non-drafting party, that's the library, that works with a vendor, to have more discretionary authority. That's one of the ways that we as librarians can have some negotiating power. Declarations are basically provisions that manage the contract policies. So today we're talking about publication agreements or publishing agreements, and they invoke two sets of different laws. They involve the copyright of the author through a transfer, which is a legal instrument. Transfer, assignment are used interchangeably to mean that one party is giving his or her rights to another party. So just think in terms of, we're talking about intellectual property here. Think of it in terms of like a sale, and when you are dealing with real property, you're selling a house or a car or what have you. So this is kind of the equivalent to this in the IP world. And the legal instrument that's involved here, of course, is a contract. Also, within that particular publication agreement, there may be another license. So we're going to delve into the details of that, but keep in mind that, it's sort of like a contract within a contract idea. So Stephen is going to do a run through of copyright basics.
Hi all, it's Stephen here. So when we were putting together this presentation for today, we decided we really wanted to cover a few of the basics of copyright, even though as information professionals, I think many of us have a good idea of some of the basics of copyright, but just to get everybody on the same page. And in fact, looking at the audience, I see some people have fairly extensive backgrounds in copyright. So we're not going to go too deep into the weeds here, but we do want to, again, get everybody on the same page. So first, what is a copyright? This is something that you'll hear lay people confuse very often as to what's a copyright, what's a patent, and what's a trademark. People say, I'm going to trademark that when they don't really mean trademark. It's fairly common. Either way, copyright is a property right the law gives to authors over the creative works. And this is important that copyright covers creative works. It doesn't generally cover things like inventions, which is the subject matter of patents. So inventions are useful items, tools, something you do something with, whereas creative works are something like original creations of the mind, maybe, something like this. And it's important to note, or at least interesting, that copyright starts from the Constitution. It stems from the Constitution. Article 1, Section 8, Clause 8 of the Constitution gives Congress the power to create copyright law. It reads, to promote the progress of science and the useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. And I think it's it's interesting that this idea of copyright goes all the way back to our founding and even earlier, going into English common law. So today, the law protects authors, copyright and works that are original, creative, and fixed. These are the three bars, the three things that all copyrighted works have to satisfy in order to have a copyright. They must be original, means it can't be a copy of somebody else's work. It has to be creative, and it only has to be like a little bit creative. It doesn't have to be incredibly creative, but it does need to be something more than just a rote application. And then fixed in a tangible medium of expression. It's important to note that fixed is sort of it's a little bit of a wishy-washy term. Something could be fixed even for just a very brief moment, and that's fixed enough for copyright. I do want to note that there is sort of sometimes a misconception that these three bars basically don't exist, that essentially anything can have a copyright, but this is not in fact true. In fact, I'll point out one recent case that American Airlines is going through. So American Airlines recently tried to register a copyright for a new logo that they created, and the Copyright Office bounced it, saying that it wasn't creative enough. So these are in fact bars. It's just that they're kind of low. But it is important to note that you don't need to do anything other than create to get a copyright. You don't need to register your work any longer. You don't need to deposit it with the federal government. You don't need to use the copyright symbol or anything else. All you need to do is create. Of course, registration of your copyright offers some benefits, like it allows you to sue on your copyright. You can get statutory damages in some instances, things like this. But you don't have to do that to secure their rights themselves. It's an important distinction. It can be a little bit confusing. But it is important. So what does copyright protect? So 17 U.S.C. 102, the statutory provision that defines the subject matter of copyright, lists 8 categories of works that copyright protects. There's literary works, musical works, and this includes the words. And so a musical work is like the music that's written on the page, like the notation, the notes, any sort of lyrics that go along with that. The dramatic works, pantomimes, so you can actually have a copyright over choreography as long as it's recorded in some way, pictorial, graphic, and sculptural works, motion pictures, sound recordings. So sound recordings are the other side to recordings over music. So musical works is the underlying written component of a piece of music, whereas a sound recording is the actual recorded performance of that musical work. And then architectural works. So what doesn't copyright protect? And I think this is as important as what copyright does protect. So 17 U.S.C. 102b says that copyright doesn't extend any idea, procedure, process, system, method of operation, concept, principle, or discovery. So again, these are things either that exist just in the world or maybe the subject matter of patents or things like this. Again, they're not creative works in the same way that we think of your stereotypically copyrighted work like a book or a piece of art. Copyright doesn't cover facts. It doesn't cover titles, words, or short phrases. This can be somewhat confusing. Again, people will think that you have a copyright over the title to your book. That may not be true because copyright just generally doesn't extend over titles, words, short phrases. Copyright doesn't protect the works of the federal government in general. There are some exceptions. There are exceptions to a lot of this. And then copyright doesn't protect works created by not created by human authors. And I point this out mostly for amusement. There was a case out of the Ninth Circuit recently, Naruto v. Slater, which dealt with this macaque that took a picture of itself. And PETA, the organization, claimed that the monkey should have some sort of rights over that work. But in fact, non-human authors cannot hold copyright, at least as of right now. So we wanted to point out something called the idea, expression, and dichotomy. And you've probably all heard of this, or you may have all heard of this before. And this is this idea that we've already sort of addressed. The copyright doesn't protect ideas, but instead it protects the specific expression of those ideas, how they come out. So the underlying idea is not protected by copyright, but how you tell the story is. And the example I often like to give for this one is that copyright doesn't really protect the idea of a story about a boy wizard who goes to school with other wizards and fights bad wizards and has other wizard friends and things like this. Copyright doesn't protect those ideas. Copyright does, however, protect the specific story when you start adding in things like this boy has a lightning bolt scar over his head, his name is Harry Potter, he goes to Hogwarts. That's when copyright comes to protect J.K. Rowling's work. Okay? And it's often best to think about copyright instead of one single right as actually a collection of rights or a bundle of rights. And these are several different ways that authors can control the usage or reuse of their work. When we're looking at the bundle of rights, we look at 17 U.S.C. 106 that gives authors rights over the reproduction of their work. So that's what a lot of people think about when they think about copying, like photocopying, reproduction. Creation of derivative works. So a derivative work is a work that's based on the original work. Sometimes the people think of this like sequels. You could think of it as like a novelization of a movie, or vice versa, a movie version of a novel, things like that. Now distribution, that is, actually handing out individual copies of the work. Public performance, for a book, you might think of it as reading it orally, but it's a little bit confusing, more confusing than that. But the public performance of the work, the public display of the work, and specifically for audio recordings, the performance by digital audio transmission. And as we're getting close to the end of this review of copyright, I want to point out that copyright protects the authors first. So 17 U.S.C. 201 says that under normal circumstances, the copyright initially vests in the person who created the work, the author. There are some exceptions to this. Again, there's exceptions to a lot of this stuff. But in general, the copyright vests initially in the author. And then importantly for what we're going to be talking about today is that the law also gives authors the right to transfer their copyrights. However, in order to transfer a right, that means, and by to transfer, we mean to give somebody your copyright in whole or in part for all time, it has to be done in a written document. You can't just say, you can have my copyrights verbally. That would be something more like a license that allows the person to use the thing, but it's not actually a transfer of the right itself. And further, the law also allows you to subdivide these rights. So you can give some, parts of the bundle of rights over and not others, things like that. So at this point, we're going to turn to publishing agreements. And we're going to look at a specific publishing agreement from Springer Nature.
Okay, so you may not be able to actually make out all the provisions here because it's very small font, but we have chosen a number of them to actually analyze with you. So first we're going to look at the IP transfer provision, which is sort of the heart of this contract. It's the consideration. And the keywords are here bolded. In consideration of the publisher evaluating the contribution for publication and publishing the contribution if the publisher so decides, the authors hereby assign where relevant by way of present assignment of future rights to the publisher with full title guarantee all copyright and other intellectual property or related rights in the contribution throughout the world for the whole term of copyright, including any renewals, reversion, revivals, and extensions. And so the key things to consider here are, number one, the consideration. What is the author giving to the publisher, and what does the publisher need to do and to publish the paper? So we're going to take a look at this in more like a simplified graphical representation to kind of just get our minds around what's happening. And so the author and the publisher are color coded, and the arrows denote what the author is giving to the publisher and what the publisher is giving back to the author in return. So this goes to answering the questions of what, how long, and where. And primarily the author is giving to the publisher, assigning the publisher all his or her copyrights and the related rights, which include the IP rights. Let's say if the author has any kind of trademark or patent interest that are related to the contribution at issue, then the author's giving all of these things to the publisher. And you may remember Stephen talking about the bundle of rights, which is reproduction, distribution, and so on. So in this particular case, the publisher is asking that the author give all of those, the entire bundle. How it's through assignment, of course. And assignment means that you're assigning your particular rights to another party. You're giving your rights to another party. For how long? It's the whole term of copyright, which the rule of thumb is life of the author plus 70 years, where it's a worldwide. And let's take a look at what's in the red font here. What is the publisher giving back in return? You know, what is the nature of this consideration? The publisher is essentially evaluating the contribution for publication and publishing the contribution if they so desire, you know, if they decide it's worth publishing. So that's it. That's what the author is gaining from this exchange. The evaluation of the paper and publishing it if the publisher decides. And so we're going to delve a little bit deeper into the IP license provision itself and take a look at what the publisher is giving. So the publisher hereby grants to the author a license, a non-exclusive license, a non-transferable rights, provided that, remember we talked about conditions in the licensing session. So the language provided that denotes conditional language. So those are the things that the author has to do in order to get that grant. That the rights must not be exercised before first publication of the contribution in the journal. Secondly is that when reproducing or referring to the contribution, the author must include an acknowledgement of the publisher's ownership. And so after the author clears those particular conditional hurdles, then what's being granted is the reproduction, or to allow a third-party publisher to reproduce the contribution in whole or in part in a printed volume. So reading the fine print is really important here, so as to when you're, let's say, going through such a similar exercise with a faculty member or a student, and they're wanting to know, well, I've published this paper with Springer Nature, what can I do with it after? You know, so those are the things that are being granted to the author. Reproducing part or the whole contribution in a printed volume. Secondly is posting a copy of the contribution as accepted for publication after peer review. And this is kind of an important thing to make a note of, is what version of the paper. And typically publishers, of course, will not want to give that grant for the paper as published as it appears in their journal. So that would be as accepted for publication. And where does this copy where can it get posted? It's on the author's website, institutional repository, or the author's funding body's archive 6 months after publication. So, and here is kind of where it's important to make a note of what the publisher is allowing the author to do with regard to if you're working with a faculty member who's trying to understand what they can and can't do for their funding agency. Also make a note of the 6 months embargo period here, which is different from the 12-month embargo period that occurs with the federal granting agencies. Lastly, the author is allowed to reuse figures or tables that are contained in the contribution. And the interesting thing here is to kind of limit the scope of that to oral presentations and other works. So other works seems to be kind of broad, but oral presentations is very narrow, and somehow the author's supposed to kind of navigate that. Okay, this is a simplified breakdown of the IP license provision in bold. And I basically kind of talked through the fuller version, but again, here it is in a very graphical, simplified way to just represent what the license back provision does. And this is just more verbiage in terms of what does the author get with regard to that particular consideration in the license back provision. Also note that there are further conditions to where in the first bullet under what does the author get, take a look at subject to the publisher's prior written approval. In the second bullet, take a look at the language that says provided that they also link. The notation of provided that, that's further conditions. And remember we talked about conditions as part of the licensing session, and we talked about that conditions are usually attached to something else. So in a sense, this is kind of a condition within a condition, and it's really important to pay close attention here to what the author is being granted to do or not to do. Okay, let's talk for a moment here about what does the publisher actually need in order to publish a paper. All they need is to be able to reproduce, distribute, display, and have right to first publication. So this kind of begs the question of, is the publisher overreaching in what they're asking for, the entire bundle of copyright throughout the world and all of this really broad language? And this is where kind of your evaluative, mode of thinking should come in. Does the publisher need the full copyright of a work? And the true answer is really no. They just need those particular right to first publication to get the work out there. There are tools out there, and I'm sure many or all of you are aware of this, but just to kind of, for us to be all on the same page, that there are tools such as the Spark licensing addendum to help kind of sort through what the author can try to push back on and try to retain. So I'm going to turn it over to Stephen to talk about moral rights.
So what are moral rights and why are we talking about them here? Well, there's a provision in this contract that says the authors hereby waive or agree not to assert, yada, 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 any moral rights. And what the heck's a moral right? Well, as it turns out, Springer Nature is based out of the UK, and so they wanted to mention this thing called moral rights, which is more of a concept in Europe than really it is in the United States. So moral rights are rights to things like, they're sort of copyright adjacent. They're rights to things like right to attribution, right to publish anonymously, right to the integrity of the work, maybe the right to withdraw the work, like you've distributed it, but you no longer want your manuscript out there, you can pull it back maybe. Again, these are things that we don't really usually recognize in the United States. Sometimes people think there's this right to attribution. You often hear people on YouTube say, well, I said where I got the thing from, that means I'm insulated from copyright. Well, that's not really true, but there is this moral rights idea to the right to attribution. And like I said, moral rights are primarily recognized in civil law countries, sort of most famously France. And of course, the U.S. is a common law country. That being said, the United States does recognize some limited moral rights in the Visual Artists Works Act, VARA. You may have heard of this. It's 17 U.S.C. 106A. And it gives some visual artists the rights to attribution, protection from destruction of their work, or they can prevent the misuse of their name on a work that is incorrect. But again, in general, the United States doesn't recognize these. It's in this contract because this contract is coming from the United Kingdom, and they're sort of aware of that. So you may not see this sort of thing, but if you do, that's what it's talking about. There's also a rights reversion provision in this contract. It says, if the contribution is rejected by the publisher and not published, all rights under this assignment shall revert to the author. So that means as it says, you submit your manuscript, your journal article to this company. They can sit on it for a while, and then if they decide not to publish your thing, you can go and take it elsewhere. Your rights come back to you. However, let's understand the structure of this, right? The agreement says first thing you do is you assign all your rights to us, and then we give you no time frame on which we're going to make this decision, and then we can, take our time, and then eventually maybe we'll give them back to you. And notably, you can't share your work. Okay? So again, after you've transferred your rights, that's you've sort of given up your rights, right? And you might get them back if they choose not to publish, but that's, it's not clear when that's going to happen. At this point, I do want to mention there's this, we're just going to branch this briefly. There is a statutory way to terminate transfers. You may have heard of rights reversion, statutory rights reversion under the copyright law, or statutory termination of transfers. It's 17 U.S.A. 203. It allows authors to terminate a copyright transfer and licenses after 35 years after it was made. Now, I'm not going to get too deep into this. There are some very specific rules for how to go about doing that, and we're starting to see these things actually happening for the first time. So if you do need to terminate a transfer, you can after 35 years, as long as you follow the rules. This contract also has, and as we mentioned in the previous two talks, choice of law and choice of venue provisions. So this is a provision that says if there's some sort of disagreement that arises under under this contract. So for the subject of this journal article that you've submitted, then it says what law governs and where you can bring a lawsuit. And in this particular contract, again, since it's an English contract, it says that the laws are going to be the laws of England and Wales. And if you want to raise a problem with this, you have to do it in the UK. So obviously, if you're signing this as a U.S. author, that could be difficult, or if you're located somewhere else, you have to bring your suit in the United Kingdom, and you have to know something about UK contract law, UK copyright law.
Okay, so our main takeaways for today are, just to wrap up, publishing agreements are negotiable. Publishers only need certain rights to publish. They don't need the entire copyright bundle, but they ask for it anyway. Publishers often ask for the author's assignment of full copyright. Then there will be a license back provision. Basically, you want to pay close attention to which rights you or the person that you're working with have assigned and which ones have been retained. Publication agreements are context sensitive, and that often, when I'm speaking to a student submitting a PhD ETD into our open access repository, the conversation is different from speaking with a faculty member about their peer-reviewed publication or a book contract that requires royalties and so forth. So knowing the context could kind of help navigate the conversation a little bit better. And hopefully you have gotten something out of this in such a way that could inform and make your conversations around scholarly communications issues a bit more richer and fulfilling. So I hope you all have enjoyed these series. I know we have, and having seen the repeat customers sign up for 2 or more sessions was very rewarding. So thank you all so much.
And we're happy to field any questions if you have any. I do want to mention one thing that I was thinking about while listening to Marianne talk about the license back provision. I think it's interesting that they give you the right to quote unquote post your work in a variety of places, including your website and things like this. The word post is not, there's no legal effect to that. So 5 years from now, maybe nobody uses the word post, and it sort of loses its meaning. I found that to be an interesting provision.
Well, just to follow up on that, yeah, Stephen's absolutely right about the posting effect, but I would take that to mean reproducing and displaying. I think that's what the publisher means, but just didn't quite say it that way.
And John, if there are any questions, we're happy to field them. It looks like John is having audio trouble. So if you hold on 1 second, perhaps we can answer some questions, or if not, feel free to email either of us or both of us. We'd be happy to try to answer whatever questions you have.
Hey, folks, this is John Berger. Can you all hear me now?
I can hear you.
Phew. Sorry about that. Not sure what happened. Question that arose was, you reviewed the example from Springer Nature, sort of with these broad assignments of copyright for ever and ever, anywhere on the planet. Is that typical for commercial publishers, and are you seeing any flexibility as these issues are getting more and more widely discussed?
Do you want to answer, or shall we both? So it's been my observation that publishers are so there is room to negotiate. So for instance, the Spark Addendum, the purpose of it is to say like, hey, rather than just transferring the copyright, why don't I just license you the rights you need in order to publish the thing, but I actually get to keep, the author, get to keep my intellectual property rights. And publishers are increasingly more open to at least discussing this. This transfer of intellectual property is sort of, in a lot of ways, a holdover from the past when it was just the default. But today, it's becoming more common for publishers to just ask for a license, or to, again, be open to negotiate, so that you don't actually have to transfer full copyright and then with maybe a license back.
I have seen questions from faculty where they ask to license work in perpetuity to the publisher. Is that the same as giving over their copyright?
It depends on the license. So let's say you were to say, I am going to give you a exclusive, non-transferable license in perpetuity to all of my rights under copyright, but it's only a license and I have nothing left over when I'm done with this. That's pretty much transfer copyright, right? Even though it says like I'm licensing them to you. However, if it's a non-exclusive license, right? So that means you can license it to other people. That would not be a transfer of your copyright. Like what you could say is, I'm going to give you the right to reproduce this thing into perpetuity, but I can give John the right to copy it into perpetuity.
Very good, very good. Those are the questions that we have right now, folks. We had a couple folks ask about getting copies of the slides and the recording, so we will get those posted on the ASRO website later today. And sorry, we had a number of people who dropped out when I was having my audio problems, so apologies for that. At this point, I do want to offer my heartfelt thanks to Marianne Burright and Stephen Wolfson for this and all 3 sessions. It's been very useful and great fun, and really appreciate your thinking of ASRO when you have these sorts of ideas. So that's it for today. Thanks again to everybody for your time and attention. This is John Berger signing off. Take care, everybody. Bye-bye.
Thank you all.
Bye-bye.